All right, I call cause numbers 10,734 and 10,735. Each case is styled the state of Texas versus Billy Rodriguez. This is a pretrial hearing in these two cases. These pretrial hearings are being conducted by remote video teleconferencing technology using the Zoom protocol, and they're also being live streamed on the court's YouTube channel, all of which is to comply with the Supreme Court's orders, Texas Supreme Court's orders, and rules and directives from the Office of Court Administration during this pandemic that we find ourselves in. Because the hearings are being presented in the manner outlined, I enter an additional order prohibiting all parties, any and all parties, from recording this proceeding in any way, by any means, electronic or otherwise. Anyone violating that order is subject to being held in contempt of court. There is an exception to this prohibition, which applies to the court reporter for this court. And the official court reporter is in fact recording this proceeding at the direction of the court, just as he would do so in a live hearing, in-person hearing in court, in the physical courtroom. Those pronouncements being made for purposes of pretrial in these hearings, in these two cases, what says the state?
State's ready, Your Honor.
And defense?
We're ready, Your Honor.
Do we have any pretrial matters to take up in Mr. Rodriguez's cases at this time?
The state does not, Your Honor.
Your Honor, I have filed a motion to re-urge my suggestion of incompetency with respect to Mr. Rodriguez. It's a little more detailed. It's not just a basic motion, but it also makes reference to the prior report and I think my earlier motion. And to grant the motion would probably require that Mr. Rodriguez's case not be tried this month. Just my suspicion. And so I guess built into that request for additional exam is that the case be continued until Mr. Rodriguez can be re-examined if you would grant that motion. So that's what I've got, Judge. That's what I would urge. Do you need testimony, Judge, or is it sufficient the arguments of counsel prior to the hearing?
I believe your motion is sufficient on its face. The court believes it understands the nature of your motion. I'm looking at the physical document itself, and it appears that a page is missing. That being the signature page. And I've heard it said that some appellate courts won't accept something unless the signature page is signed by the attorney and maybe others. So I don't have the signature page in front of me.
Judge, what can I do to remedy that? I don't have a hard copy in my file, or I would somehow by courier get it to you in the courtroom. May I email it to you?
No, let me ask my coordinator, is it in the electronic file? It's the motion re-urging suggestion of incompetency and request for examination.
Let me pull it up.
All right.
I suspect that it's in the court's file because the one that that I printed off from my file contained the signature page.
Good. Good. I haven't been able to get an e-file signature that is my signature. I've had to rely on that, whatever font. If I can figure out how to get my signature on there, I will.
Judge, it's in iDocket. Do you want me to print out the last page for the file?
No, it's not necessary. I'm opening up that myself. All right. Back to the question that was before us, which was whether the motion is sufficient by itself or whether it requires evidence. I don't know that evidence would add anything, or the evidence that you could present, except, I guess, your own testimony. One of my questions would be, is it necessary to have Dr. Dunham do the reexamination, or should someone else provide us with a different examination?
Judge, there would be benefits to both, I suppose. I mean, there's, on the one hand, I think it would be helpful for Dr. Dunham to have the benefit of having interacted with Mr. Rodriguez previously to compare, his impressions. But on the other hand, we typically don't see an evaluation that is qualified in the way that this one was. I personally am sufficiently familiar with Dr. Dunham's work that he's been involved in, I would think, 20 cases where I've been the attorney. And I haven't always agreed with him, but I've always appreciated his work. I think I'm making sense there. I don't believe that this evaluation, for instance, is indecision that might be addressed by a different evaluator. I don't think that. But objectively, because it is a strange situation that I've described in my motion, it might be most useful to have a different evaluator do the exam. So there it is, Judge. I would be happy either way. If just to have a subsequent exam. That is about helpful is not very much, but that's my position.
Mr. Smith, what's the state's position? And elaborate just a bit further on a question that's running through my mind, which is, if the report comes back that behavior or thought processes are a bit strange, might we end up with either a battle of psychological experts. That is, even if they both determine, if there were two, that the defendant is experiencing some delusional thoughts. And by delusional, I mean some thoughts that are not factual, and is relying upon those unfactual or non-factual thoughts as to whether he is competent or incompetent to stand trial. Where are we? That's the problem I'm having with the motion.
Yeah.
That just because there may be some thought processes that are allegedly and maybe even demonstratively incorrect, that's not terribly unusual in a criminal case.
Right, right. And I think what the doctor, and I believe what the incompetency law will hang its hat on, is whether or not the false beliefs or incorrect beliefs are a symptom of a mental health problem. And if there is a mental illness, mental health problem, that's evidenced by that, then they can diagnose that. And then if they can make the next step and say, because of this mental health issue, the person is not able to, is not competent because they can't cooperate in their defense, and all of those things that fit into what makes a person incompetent. So that, again, was kind of what concerned me about what Dr. Dunham said before, which is he seems to be have these, I think he termed them false beliefs, and they may be indicative of an undiagnosed mental health issue. And if he persists in these beliefs, he could possibly need to be evaluated again. And for that reason, I might say, and I could see the pros and cons of going with a different doctor, and I can see the pros and cons of using the same doctor, but at least maybe Dunham has a handle on the idea of these false beliefs, and he will get a second opportunity to discuss those with Mr. Rodriguez and perhaps flesh out better whether or not there is a true mental health issue there, or if it is just, as we've been discussing, frankly, just believing something that is not true, that is not indicative of a mental health issue. It's something else.
I think too, if Dr. Dunham were to evaluate again, I believe his second evaluation, by its nature, the fact that it would be his second evaluation, I believe that it would be more definitive, one way or the other. When you were asking about the potential judge of a different evaluator, one of the things that came to my mind was the thought, well, what if his report was qualified as well? And so that's why I go back to saying I do have a preference for Dr. Dunham, because I think his second evaluation would be more definitive one way or the other. I think that.
Well, my concerns are sort of twofold. One, Mr. Rodriguez has been in jail for a long time in Scurry County. A long time in Scurry County is not quite the same as a long time in Harris County or some other county where cases are not disposed of as quickly as we dispose of them. So on the one hand, I'm concerned that we just have somebody in jail without giving them a chance for trial. Second, but we are in a strange time in our world due to the pandemic. So that doesn't excuse the concern or eliminate the concern about somebody being kept in jail for a long time. But it does help to explain why that has occurred, because we've been in a position to go to trial several times and then they not be able to go to trial through no fault of the court or the defense or the state. Anyway, that's one concern. The other concern is, even if Dr. Dunham or any other physician, psychiatrist, or Dr. Dunham is a psychologist, evaluates Mr. Rodriguez and concludes that his beliefs are factually incorrect and there is no basis in fact for those beliefs. I've never heard of that resulting in a determination that a person is unable to understand right from wrong, or, which is the basic insanity question, or that he is unable to assist his attorney in preparing for trial, or because it's just not unusual for a defendant in a criminal case to assert that he believes a fact that does not in fact exist. And I'm just having a hard time getting past that as a that is the situation here.
The only thing, Judge, to me, that distinguishes this alleged false belief or set of false belief from others simply regarding, say, the occurrence or non-occurrence of elements of the offense. Right? This is different from simply recalling the circumstances of an alleged offense incorrectly, or even just by sheer will, delusionally. This false belief goes to the very status of the case, and Mr. Rodriguez's perception is that he's not in jeopardy, in spite of all the evidence to the contrary, like the fact that he's sitting there in jail right now. His belief to the contrary, that he's not in jeopardy, undermines his ability to appreciate what's going on here. Just that fact by itself. And I think that's where I would want to hang my hat, that's why I think it's a problem and not merely an incorrect belief regarding the circumstances of the case.
I just had something come to my mind as you were discussing it, Mr. Keith. This past weekend, I was in a social setting, and another man came up to me and was discussing things in general, and he said, "What do you do for a living?" I just simply said, "I'm a district judge." And he said, and this is not terribly unusual, "Oh, well, let me tell you about," and he starts explaining how a nephew of his in another state And he explains somebody who is got a good job, highly educated, married, doing all kinds of right things. And his wife takes a 5-second video of him and playing with his child in the floor. And the wife then presents that to law enforcement and says, "My husband was smothering our child. Here's video proof of it." The guy gets charged, says the person who walks up to me at the social gathering. He bonds out. A bounty hunter comes and re-arrests him and puts him back in incarceration. And then the divorce proceedings result in a judge telling him he has to pay the wife cash out of his 401k plan at work. And he sets up scenarios where ultimately the guy is ordered by the judge to be found in contempt of court, to be put in jail, and ordered to pay all of this money in one lump sum payment, which the man doesn't have because it's in the 401k plan, and assesses 12% interest and all that kind of stuff. And the thought that's going through my mind is something is amiss here. Those things don't happen. There is something that person who's talking to me, you have misunderstood. There is something that your nephew is misperceiving. There is something factually wrong, because those factual assertions do not result in the kind of outcome you're talking about. Either the man didn't know what he was talking about, or somebody was not telling him the truth, but he believed it. He believed it was true. He believed what his nephew told him was true. But it cannot be true. It does not work that way. Our system does not work that way, even in another state known for its that is politically different than our state. So I don't want to identify things. That doesn't mean that person is mentally incompetent. It doesn't mean he is insane. It means he has internalized a falsehood and repeated it to himself enough that he believes it. That doesn't mean he's not competent. It doesn't mean he's insane. It means he is factually incorrect and refuses to admit the facts.
Sure. Especially in that example that you used. And I would hope that he was rational. And if someone were to pull him aside, like his son or nephew, whoever it was who was the subject of these maltreatments that this fellow had in his mind, then presumably that fellow would know the truth. And if that fellow, in fact, were to be honest and forthcoming, he could set this guy straight. He could correct those misbeliefs. And those misbeliefs are also, I mean, the person you described isn't also charged with a crime. You know, and I know you know that. I'm not oversimplifying, Judge. But in spite of all the evidence, there seems to be more to this than just, I mean, it may be cognitive, it may be where, yes, absolutely. But it is nevertheless a persistent, troublesome, and I would say it is in the way of me representing Mr. Rodriguez effectively. I believe it is in the way. Mr. Rodriguez himself probably doesn't think so, but there he sits, and still, I don't want to reinforce the the negative belief or the belief that I disagree with, but you know what it is, Mr. Smith, and Mr. Rodriguez remains in custody, and he believes that he's there for the. I can't do any better than what I've done, Judge. I know that it's strange, and you could analogize it to some fairly innocuous things, but and I can't overcome those. But I do feel like it's my duty to bring to your attention, and for the sake of Mr. Rodriguez's due process, to urge what I am urging, and that the additional exam be performed.
All right.
Do you need me? No, sir.
On the one hand, Mr. Rodriguez's continued incarceration, as I've already stated, is troubling, that we're forcing that upon him. But the other side of that particular coin is the allegations in this case are of such a nature that if he were to be convicted, he might be looking at an automatic, he would be looking at an automatic, is that right? He'd be looking at a life sentence.
Yes, sir.
That's right.
And so, which is generally reserved for someone who is a danger to the community. And so he is not a danger to the community while we examine whether or not he should be treated differently. That is, as a result of not a result, whether he should be treated for a mental health condition as opposed to being treated as a dangerous person because of criminality. I can not worry as much about his incarceration, additional incarceration that would result from postponing this case one more time to allow an additional examination. So I will grant your motion. And I don't remember if we had some of this discussion on the record or off the record. But either way, you advised Mr. Keith that you had contact with Mr. Dunham to inquire if he would be willing to examine again, something along those lines.
Yes,
and he advised that he would be willing to do so, but he would not be able to do so until at the end of this month, which would be after our trial docket.
yes,
Is that
sir.
all? Is that correct?
Yes, sir.
All right. And so that was one of the other reasons I was inquiring about having somebody else examine Mr. Rodriguez. We have some degree of confidence in Dr. Dunham because he has assisted this court and other courts in these psychological examinations in the past. And so I want to grant the motion. Give me an order that orders another examination. And Mr. Smith, I don't know if it's your order. I would appreciate to both of you conferring on the wording of an order that would accomplish what's being requested, but at the same time, not allow us to go off on wild goose chases.
Sure. Trey, if it's okay with you, I've got a bank of forms for these kinds of things. I'll prepare an order and a proposed order and send it to you.
Thank you, Ben. That's great. Yes, sir.
All right. Then is there anything else that we ought to consider in Mr. Rodriguez's cases while we're here this afternoon?
I have nothing else, Your Honor.
Not from the defense, Your Honor.
All right. Thank you, Mr. Rodriguez. You may be excused. Has anybody heard of whether Mr. Ariano has shown up?
No, Your Honor.
I'm told he is at the jail.
Is he in custody or?
No, appearing at the law enforcement center.
Okay. All right. Well, let's.
Deputy McAden, would you get Mr. Ariano into the Zoom
We've
kiosk?
already got him coming back, sir.
Okay, thank you. While he is coming back,